government in this area. And the basic rule of the Commerce Clause, the Negative Commerce Clause, comes down to this. States can pass laws that regulate interstate commerce, but they must not discriminate against interstate commerce nor unreasonably burden interstate commerce. So they can regulate in the same area, but they may not discriminate or unreasonably burden interstate commerce. Now, to break this down into the two areas of discrimination that we have and the kinds of burdens that we're thinking about, let's look first at discrimination. The absolutely strongest argument that you'll have available to you to invalidate any state or local law under the Negative Commerce Clause is that it discriminates against interstate commerce. There are two kinds of discriminations that you can find, depending upon why the government is discriminating against interstate commerce. The first is where the state discriminates against interstate commerce for the sole purpose of favoring in-state commerce, where it's purposefully discriminatory. And where that's what the state is about, where that's what it's doing, those kind of laws are going to be per se invalid. You may not discriminate to achieve an economic advantage. That's a bad thing. Any state, for example, that places a tariff or an extra tax or cost on out-of-state goods but doesn't apply to in-state goods, or that gives their in-staters a preference, let's say over the use of state resources like oil over out-of-staters, or that mandates that local businesses first purchase inventories from in-state vendors, or anything like that, where in essence what you have is an economic advantage preserved for in-state consumers or in-state businesses, that is per se invalid. As a matter of fact, this sort of parochial, us against them, we're taking care of ourselves and let the other states be damned, that kind of attitude was the prevalent attitude under the Articles of Confederation and the very purpose that the Commerce Clause was vested in Congress. So any kind of protectionist, discriminatory legislation of this character will be struck down. And there are many examples where this has happened. There was a fairly recent case, Wyoming versus Oklahoma, where the court struck down as discriminatory and protectionist an Oklahoma law that required power plants in Oklahoma to burn a mixture of coal. And that coal had to include at least 10% of coal from Oklahoma. That sort of preferential advantage for in-state resources is exactly the kind of thing that's per se invalid under the Commerce Clause. Now, there's also a second kind of discrimination, and I suppose I should note, discrimination means treating out-of-state commerce worse than in-state commerce, or preferring in-state consumers or in-state businesses as against out-of-state businesses. And pretty much you'll be able to find discrimination if it exists on your facts. I'll just note here, though, that you can face a threshold issue. It might be ambiguous. So before you argue discrimination, see if there's some reason to grapple with the question about whether discrimination actually exists. State laws can discriminate in purpose or effect. We're talking about purposeful discrimination for economic advantage. And we're now going to talk about another form of discrimination, but you might have to look for discrimination. The other kind of discrimination against interstate commerce is one where the state is discriminating, but it's saying that the purpose of its law was not to achieve an economic advantage. It isn't protectionist legislation, but rather the state says it's to serve legitimate health and safety reasons under the state's police power. And yet the effect is still discriminatory. When you have that on your hands, it turns out that the state does have some ability to discriminate, but it's very, very narrow and limited. Some discrimination laws can survive. It's not going to be per se invalidity. And here's the rule. Discrimination, even of this character, for health and safety purposes, will be declared invalid unless the state can show that it had no reasonable, non-discriminatory alternative ways for achieving an important objective. Now, this is a very difficult test to satisfy. And I'll give you some examples where states have tried and failed to satisfy this test. One case involves the city of Madison, Wisconsin. Madison made it unlawful to sell milk as pasteurized in the city unless that milk had first been processed and bottled locally at an approved plant approved by the city. Now, the law was plainly discriminatory. And note, it can be discriminatory both as to other parts of the state, but here discriminatory also as to out-of-state businesses, because in effect, it required out-of-state companies to use in-state processing facilities as a condition in order to sell their milk there. Now, the city claimed, well, we're not doing this for economic protectionist reasons. We're doing this for health and safety reasons. We don't have a discriminatory purpose. We want to ensure, and this is our purpose, we want to ensure a supply of wholesome milk. We want to make sure that it's processed under conditions that are satisfactory to us. But the law was still invalidated, because in looking at it, the court said that, okay, we'll accept for argument's sake that you're doing this for health and safety reasons. But the court said you had ample, reasonable, and non-discriminatory alternatives to assure your residents a supply of wholesome milk. You could have, for example, used inspectors or required pasteurization in accordance with federal public health standards. You could have used ratings on the milk, or you could have examined the out-of-state plants to see whether they were up to par. You could have done lots of things other than discriminate, and so that law was struck down. Similarly, you had a law struck down in the case of Philadelphia versus New Jersey. New Jersey prohibited the importation of garbage into the state from outside of the state. Plainly discriminatory. The court said that garbage, although it's garbage, is an article of commerce. And it said, in effect, that New Jersey was erecting a barrier, and it was, on all out-of-state waste, so it was discriminatory. But New Jersey came back and said, wait, this is not protectionist. We're not doing this for economic protectionism. We're doing this for health and safety reasons. We want to preserve our state resources, the landfills, for conservation, environmental purposes. We're not doing it for economic protectionist reasons. And the court said in that case, okay, maybe that's true, maybe it's not, but we'll accept that that's why you're doing this, that you're doing it for health and safety reasons. Still, the law is no good. Because, the court said, you haven't even tried, New Jersey, you haven't even tried reasonable and non-discriminatory means of dealing with the problem, and therefore the law is struck down because you can't prove that there aren't any other reasonable and non-discriminatory alternatives. Now note, you can have a rare case, and it would be a rare case, where a state could survive this test. One such case actually arose recently in the case of Maine versus Taylor. Maine banned the importation of bait fish, live bait fish, into the state from outside of the state. Now, again, plainly discriminatory on its face. But here the law was actually upheld. Maine said, first, we're acting for health and safety reasons. We're not doing this for economic protectionist reasons. We're worried that our bait fish are going to be at risk from the out-of-state fish because the out-of-state fish carry parasites. And the idea of protecting the living things in the state, the fish and so on, was a sufficient police purpose, environmental protectionism, not economic protectionism. And second, and here's where statutes usually fail, but Maine survived, Maine said, we have no reasonable and adequate non-discriminatory means of protecting these fish. There was no test for the parasites. Maine couldn't figure out which fish had it and which were okay. And there was no cure. Even if they could detect the parasites in any infected school that came in, they couldn't do anything about it. So here you had a case where they survived this narrow test. And you can have a truly necessary quarantine-type law upheld under this test. But again, it's very, very rare. Now, the second way you can strike down a state law as violative of the Negative Commerce Clause is if it imposes unreasonable burdens on interstate commerce. And in determining whether a state is unreasonably burdening interstate commerce, the court has given states very wide latitude. It allows them to go some considerable distance. what you have to find is that the law is both excessively burdensome, and I mean excessively or extremely